Legal research methodology, tools of study, judicial scrutiny by the Supreme Court of India. Judicial scrutiny by the Supreme Court of India. The presence of judicial substantiates the theory of separation of powers, wherein the other two organs, that is, legislature and executive, stand relatively apart from it. Judiciary is a final authority in interpreting legal issues and constitutional arrangements. The nature of democracy and the development of the state depends upon how the legal system conducts itself to sustain the overall socio-economic and political environment. Supreme Court is the apex body in India. It's an extension of British legal system. The Supreme Court is supervise and govern numerous um, courts are as per Article 129 of the Constitution of India. Article 129 of Constitution of India makes a Supreme Court as a court of record. Once again, I repeat, Article 129 of Constitution of India makes the Supreme Court as a court of record and confers all the powers of such a court, including the power to punish for its contempt as well as of its subordinate courts. Article 149 of the Constitution of India provides that the law declared by Supreme Court is binding on all courts. Judiciary in India plays an important role of interpreting and applying the law and adjudicating upon controversies between citizens, controversies between states, and various other parties. As India has a written constitution, courts have an additional function of safeguarding the supremacy of the constitution by interpreting the by interpretation and applying its provisions and limiting the functioning of all authorities within the constitutional framework. Everyone knows our constitution is a federal nature. It's a union of states. The judiciary has another meaningful assignment, namely to decide controversies between the constituent states inter se as well as between the union and the states. A federal government is a legislative government, a characteristic feature of which is the allocation of power between the center and states. Legally known as the original jurisdiction of the Supreme Court of India, envisaged in the Constitution of India. I repeatedly spotlight this word. A federal government is a legislative government, a characteristic feature of which is the allocation of power between the center and states. There are three important doctrines regarding our um, scrutiny, judicial scrutiny by Supreme Court of India regarding our research methodology paper, judicial scrutiny by the Supreme Court of India. It is the tool of study. In India, it has already determined three doctrines. First doctrine is doctrine of pith and substance. Second one is doctrine of severability. Third one is colorable legislation. I simply explain this. In as per doctrine of pith and substance, that is the true object of the legislation or a statute relates to a matter with the competence of the legislature which enacted it. Through this word we can understand all the ingredients comes abiding the constitution only, um, legally validation. Otherwise, that will ignored. It is the doctrine of pith and substance. Next one is doctrine of severability. If any statute is act is passed, it has some deviations from the basic salient features of the constitution that unwanted portions become a repugnant. This is the doctrine of severability. Likewise, doctrine of colorable legislation. It's an interesting thing. Um, there may be a legislation passed by the people's majority legislature, but it should abide the salient feature of the Constitution of India. For that purpose, doctrine of colorable legislation prevents the legislatures to make laws that they would otherwise not be able to create given the constitutional constraints. Um, Otherwise, the whole doctrine of colorable legislation is based upon the maxim that you cannot do indirectly what you cannot do directly. I repeat it once again. The whole doctrine of colorable legislation is based upon the maxim that you cannot do indirectly what you cannot directly. So, as per doctrine of colorable legislation, even including Jammu and Kashmir, all other the states and provinces of India cannot uh, pass any legislation at their legislature uh, beyond the scope of our Constitution of India. If any enactment is passed, it will become constitutionally invalid. That is the spirit of the doctrine of colorable legislation. One more thing is the repeatedly we are telling our constitution as a salient features. It was introduced first time in Golaknath case. Golaknath versus State of Punjab, AAR 1967. Yes, Supreme Court reporter SC 1643. But it was only in 1973 that this phrase was used by the Supreme Court, and it means and includes those features of the Constitution which lay at its core requiring much more than the usual procedure to change them. It was held in the historic Kesavananda Bharati case that any amendment which aims at abrogating the basic structure of the Constitution would be unconstitutional. Hence, every proposed amendment is subject to judicial scrutiny if it is aimed at abrogating the basic structure of Constitution. I come to my legal research methodology paper, especially tools and study on judicial scrutiny. Every proposed amendment is subject to judicial scrutiny if it is aimed at abrogating the basic structure of the Constitution. This was established by legal legend of India. Nani Balkiwala has argued more than 77 days continuously to frame the salient features of Indian Constitution, and it should not be affected, infringed. Um, After the judgment of Kolaknath, after the judgment of Kesavananda Bharati, as because of the guidance and legal assistance of the legal legend Nani Balkiwala, we came to frame the salient features of the Constitution after the emergency enacted in 1977. It's a historical background. Once again, I repeat, constitution's elements of the basic structure include the supremacy of the constitution, republican nature, democratic form of government, secular character of constitution, separation of powers between the legislature, separation of powers between the legislature, executive and judiciary, and primarily the federal character of the constitution. It was established as a salient features of constitution because of Nani Balkiwala argument. In addition, the judiciary has also has the power of judicial review. It implies that every piece of legislation passed by the parliament is subject to judicial scrutiny by the Supreme Court of India. Now I come to the synopsis. My topic is legal research methodology. Topic is judicial scrutiny by the Supreme Court of India. I submit my null hypothesis. No specific provisions exist for this judicial scrutiny by the Supreme Court of India originally in Constitution. There is no it is not openly written in Constitution of India regarding judicial scrutiny by the Supreme Court of India or independent judicial system, independence of judicial system in India. It is not written in our constitution, but we are doing because of these salient features of constitution argued by the Nani Balkiwala after the Kolaknath case and after the Kesavanand Bharati case. We have framed salient features of the constitution to protect that salient feature of constitutions. We have given the we have given the judicial precedents and judicial activism oriented judgments, and through that process only we have uh, established the judicial scrutiny by the Supreme Court of India. Um, Once again, I repeat it. So the Supreme Court has concurrent jurisdiction with the High Courts to issue directions, orders, and writs for enforcement of fundamental rights. Article 32 of the Constitution, as per our drafting committee chairman Bhima Rao Ambedkar, says Article 32 of Indian Constitution is the soul of Indian Constitution. Even that soul of Indian Constitution is not rendered the legal entity of this term. Judicial scrutiny by Supreme Court of India is existing. So Indian judicial system is independent, and Indian judicial system is supreme than other legislative organ or executive organ. It is not openly mentioned in Article 32. That's why I humbly submit that the Supreme Court has the power to declare a law passed by the legislature null and void if it encroaches upon the fundamental rights. This is the reality. This shows how the Supreme Court has always served as a guardian of fundamental rights, guaranteed by our constitutional framers during the framing of our Constitution of India. So, whenever the fundamental rights are infringed by the legislations of state or central or especially federal nature, at that time our Supreme Court or Apex Court sumoto comes as a judicial activism process, and it protect as a constitutional guardian to protect the salient features of constitution, which was argued by the Nani Balkiwala. So because of even though we have not written provision as a law is supreme or Supreme Court is supreme, and then other three organs as per the separation of powers of Montesquieu in India, legislative, executive, judicial, all are equal power as per our written constitution. But because of after the salient features of constitution established by the Rani Balkiwala argument based on the Kolaknath case in 1967, and after the emergency 1977, because of the noble contribution of Nani Balgiwala, we have done a salient features of constitution frame. Since the Supreme Court is protecting these salient features of constitutional salient features through the judicial activism or judicial pronouncements, even though there is a de jure status for Supreme Court to Supreme than other legal organs, but de facto or otherwise in layman term, due to the practical process of passing the pronouncements, judgments, through that way of pronouncements of judgments, our Supreme Court has become overriding a role, such as a Supreme Court is highest body than other legislative organ or the executive organs, even though it is not written in a written manner of our constitution. So I come to the, so I submit my conclusion is judicial scrutiny by the Supreme Court of India. It is the tools of study. It is not written in Indian Constitution because of the salient features, because of protecting our salient features of Constitution. Otherwise, to protect as a constitutional guardian or as a guardian of fundamental rights, through the Article 32, judicial review is power is available. Otherwise, I have previously explained colorable legislations or pith and hold subject doctrine or otherwise severability, doctrine of severability. Through this process or otherwise amendment provisions in constitution I mentioned, through that process, if any violations violations is enacted through other organs like legislature or executive, at that time uh, our Supreme Court, through his judicial pronouncements, it become a guardian of salient features of Constitution of India. It gives the legal entity, it gives the constitutional validity to the apex court of or India or Supreme Court of India, such as the judicial scrutiny by the Supreme Court of India status. So, due to this above mentioned reasons, in India, even though the separation of power between the legislatures and legislatures, executive organs, and judicial system, even though all are parallel, through the judicial pronouncements to protect the salient features of the Constitution of India, and the role of Supreme Court is become overriding effect, and it becomes the law is supreme category. Thus, Indian judicial system is Indian judicial system is becoming scientifically developing evolutionary process such as a independent judicial system, though even though it is not written in our constitution. um, we will share one by one regarding this judicial review or the independence status of Indian judicial system um, through our legal research methodology. Go over to your own arena. Thank you.